Hey everyone. So we had a letter from Blake Lively in response to Wayfarer's motion for judgment on the pleadings. Well, she's angry, really angry by the looks of it too. So this is just at this stage she's only filed a she's only filed a letter requesting an extension of time. So let's go through that. Pursuant to Federal Rule of Civil Procedure 12C, Plaintiff Blake Lively respectfully requests that the court deny the Wayfarer defendant's motion for judgment on the pleadings. As untimely without prejudice to the Wayfarer defendants, raising the arguments therein in a motion for summary judgment or at trial. In the alternative, pursuant to Rule 1D of the court's individual rules and practices, Ms. Lively respectfully moves for an extension of time to and including October 27, 2025, in which to respond to the Wayfarer defendant's motion. To be clear, Ms. Lively is prepared to respond to each of the Wayfarer defendant's arguments at the appropriate time, whether that be at the summary judgment stage or at trial. As a footnote, to take just one example, the motion asserts that Ms. Lively has failed to exhaust her administrative remedies against It Ends With Us movie, but the burden of pleading and proving Title VII exhaustion lies with defendants and operates as affirmative defense. Not only does that render this argument inappropriate for resolution on a defendant's Rule 12 motion, It Ends With Us movie did not even raise this affirmative defense in its answer. In other words, not only did It Ends With Us movie move for judgment on the pleadings based on an affirmative defense it had not pleaded, but because of that failure, Ms. Lively should be entitled to judgment on this particular defense, not It Ends With Us movie. In any event, and further demonstrating the wastefulness of the Wayfarer defendant's motion, Ms. Lively amended her CRD complaint and received right to sue letters with respect to It Ends With Us movie during the pendency of this action. As is well established in this district, that is sufficient. Oh, okay. So she amended her CRD complaint and obtained a right to sue letter, which included the It Ends With Us movie LLC. I haven't seen that anywhere on the docket. That's not been mentioned. It'll be interesting if Wayfarer are aware of that. Okay. The Wayfarer defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that briefing and adjudicating them now would only lead to duplicative briefing and waste judicial resources, and would force Ms. Lively and the court to bear the burden of the Wayfarer defendant's delay. I'm pretty sure you can bring this motion at any point. Like, you know, they're entitled to bring it now if they wish to. Tellingly, although each of the Wayfarer defendants' arguments has been available to them since the outset of the case, and although their counsel alluded to the possibility of a motion for judgment on the pleadings on the record at the conference held on July 30th, 2025, the Wayfarer defendants waited to file their motion until the response deadline would fall on the last day for depositions in this case, knowing full well that because of their own discovery deficiencies, Ms. Lively's counsel would be preparing for and taking the depositions of 4 of the defendants during that period. I find this argument so rich. So rich. Okay. This This is actually Blake Lively's response to, I don't know if everyone remembers, Wayfarer filed a request for an extension of time back in April. Blake Lively and Ryan Reynolds and Leslie Sloan all jumped in to oppose it, and it did end up being denied as well by Judge Lyman. But part of Wayfarer's arguments were, look, we're having to deal with all of these motions to dismiss. We are having to reply to multiple interrogatories and responses, etc. Basically, they were being hit from all angles by all of the Lively parties. And Wayfarer were like, look, we deal with several parties and non-parties. We are responding to all of this stuff. And I think at the time, the deadline was also looming for them to amend their complaint, and they just could not physically do it because they were being hit from all angles by Lively, Reynolds, Sloan, and not the New York Times, but, the three of them were just throwing so much, and Wayfarer physically could not keep up. And they asked for an extension of time, and Lively response was basically, no, it's your problem. If you can't manage your workload, it's your problem. Just, so I find it quite rich that Lively is complaining about this, making this argument, because this is Wayfarers, and they're sort of saying, we've got all this stuff coming in, and there are 1,600 requests for production, 179 interrogatories between the parties, between Sloan, Reynolds, and Lively. And, that's what there's a lot more going on as well. There'll be all the meet and confers and emails going back and phone calls and just loads and loads and loads of stuff. So they asked for an extension. And they would not, and Lively said no. And then eventually the judge also said no. So it tickles me a little bit that Lively is sitting here moaning, well, we're going to be bogged down with depositions, and we got, like all of this discovery that we got to go through and everything. It's unreasonable that they have filed this now, knowing that the reply is on the last day of the depositions. It's not fair, and they're asking for a month-long extension, which is the same amount of time Wayfarer asked for back in April and was denied. And I will be pissed off with Lyman if he grants us. I'll be really pissed off. Meanwhile, by that time, the Wayfarer dependence motion is, by the time the Wayfarer dependence motion is fully briefed, the deadline for summary judgment motion will only be days away. So there's that as well. Like, as soon as this is all briefed and everything, they'll be ready to start the summary judgments, which I'm sure they will do. Meaning that each of the fact-bound challenges to the pleadings raised in the motion will be overtaken by the record evidence at the summary judgment stage. The question at the stage of the case is not what the pleadings allege, but what the evidence shows. No, because it's not what the evidence shows, because the judgment on pleadings is based on law alone. It's not on, it's similar to a motion to dismiss. It's got nothing to do with evidence. And the appropriate means of answering that question is through a motion for summary judgment. Meanwhile, to the extent that the motion raises purely legal issues, that it would not be affected by the summary judgment evidence, the Wayfarer defendants will suffer no prejudice from a few weeks additional delay in briefing those issues. Okay, but they're still allowed to file this motion. Lively filed her initial complaint on December 31st, 2024, and her amended complaint on February 18th, 2025. Each of the Wayfarer defendants answered the amended complaint on March 20th, 2025. In response to the court's order granting Jed Wallace and Street Relation motion to dismiss, Ms. Lively filed her second amended complaint on July 30th, 2025. Once again, each of the Wayfarer defendants filed answers, this time on August 13th, 2025. At the outset of this case, the court expedited the initial pre-trial conference and asked the parties to submit a case management plan with deadlines that would enable trial to occur on March 9th, 2026. Even with the handful of modifications that the court has granted in the months since, that goal remains in sight. Fact discovery is scheduled to conclude on September 30th, 2025, which was yesterday. With a few exceptions, including a handful of fact depositions to be completed by October 10th, and the production of additional documents withheld on privilege grounds. Expert discovery is scheduled to conclude on November 14th, 2025. Meanwhile, the current deadline for summary judgment motions is November 5th, 2025. Trial remains scheduled to begin on March 9th, 2026. I don't see how this is going to interfere with that. Federal Rule of Civil Procedure 12C provides that a party may move for judgment on the pleadings after the pleadings are closed but early enough not to delay trial. Generally, a Rule 12C motion is considered timely if it's made early enough not to delay trial or to cause prejudice to the non-movement. Whether a Rule 12C motion is timely is within the sound discretion of the judge. Okay, Judge, remember we're friends. I always get my way. That's the vibe that is giving me, that sentence. In general, if a party engages in excessive delay before moving under Rule 12C, the district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. I don't see the delay. She filed a second amended complaint on the 30th of July. She's saying, oh, you've had 9 months. She did change some of the stuff in her second amended complaint. And she made it more about how New York, how she is from New York. And it was to get Jed Wallace to keep him into New York. And I said when I did my video reading Wayfarer's motion for judgment on the pleadings that I think she's caused herself a problem by focusing so heavily on her own tie to New York. And I don't understand her argument here. Right. In general, if a party engages in excessive delay before moving under Rule 12C, the district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. I don't think it will. Consideration of the motion may still be appropriate if, unlike here, it seems that the motion may effectively dispose of the case on the pleadings. But if the pleadings do not resolve all of the factual issues in the case, proceeding with discovery and potentially a trial on the merits would be more appropriate than an attempt at resolution on the case at a Rule 12C motion. Courts are unwilling to grant a judgment under Rule 12C unless it is clear that the merits of the controversy can be fairly and fully decided in this summary manner. The Wayfarer defendant's motion is untimely. Although all of the arguments raised have been available to the Wayfarer defendants since the initial complaint was filed, they did not raise them until September 26, 2025. Measured against this court's stated rule of managing this case to a March 9, 2026 trial date. That delay was excessive under Rule 12C. Sorry, just checking something here. The motion primarily raises fact-bound challenges to the sufficiency of the second amended complaint's allegations. Those arguments are meritless, but as far as the timing of the motion is concerned, they are, more importantly, all but moot. At this stage of discovery, Miss Lively has uncovered voluminous evidence relevant to all of her claims. Well, finally. I thought when she filed her CRD and put out the New York Times article, then she had thousands of pages of evidence. Now she has uncovered voluminous evidence. Rather than merely defend the sufficiency of the allegations to respond adequately to the motion, Miss Lively would also need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint. Should any of the Wayfarer defendants' arguments prove successful as to any of the second amended claims. So the biggest issue I'm having with this is she is referring to the motion for judgment on the pleadings and saying, well, why don't we just put a pin in it and, we'll deal with everything at summary judgment. They're not the same thing. And I don't know why she's even making that argument, because judgment on the pleadings is much closer to motion to dismiss. I don't know why she keeps making that, but also I am really confused because I don't understand this sentence. Like, Miss Lively would need to, rather than merely defend the sufficiency of the allegations to respond adequately to the motion, Miss Lively would need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend her complaint. Should any of the Wayfarer defendants' arguments prove successful. What? I don't understand that. Right, this is why I don't understand it. As far as my understanding goes, just because she has found new evidence and new information, or so she alleges, in discovery, does not mean she gets to go and amend her complaint. And if she did, the discovery window would open back up again. Well, that would then affect the trial date, which she's, so concerned about in the first page of this letter. I don't think that I would be surprised if the judge was like, listen to any of that. None of that makes any sense whatsoever. I'm confused about why she's even putting it. She seems to be conflating two separate issues. I think she's worried. I think she's genuinely worried that Wayfarer made some great points and a bunch of her claims may get thrown out. Because Wayfarer they can still do the summary judgment. It is not the same thing. It is not the same standard. And I think the judge is going to be more inclined, like, if he can get rid of some of the ridiculous amount of claims that Lively has brought, if some of them don't meet the legal standard and he can get rid of them, I think he will. I think he will take that opportunity. Most judges would. And Lively knows that. but I had to sort of laugh really at this. Where is it? At this sentence. Rather than merely defend the sufficiency of the allegations to respond adequately to the motion. I mean, this woman is just ridiculous. It's just really annoying. But no, she can't just go and say, well, I've got a load of new evidence now, so I'm entitled to amend my complaint. It's not as simple as that. She would have to, move to request leave to file an amended complaint and seek permission. Wayfarer would get to oppose that. The court would then need to evaluate that evidence under Rule 15's futility standard, i.e. under Rule 12b6's plausibility standard, construing that evidence in Miss Lively's favour, along with the benefit of reasonable inferences therefrom. But crucially, that would be the same analysis as at the summary judgment stage, when, if the Wayfarer defendants choose to move against any of Miss Lively's claims or defences, she would need them to point to record evidence that, construed in her favour and drawing reasonable inferences therefrom, would support a reasonable jury's finding in her favour. So, I mean, she really does not want the judge to decide her claims on the law alone, on the legal standard. Considerations of judicial economy and common sense and the goal of holding to a March 2025 trial date support conducting that exercise only once. For similar reasons, the First Circuit has observed that the legal standard that would apply to the motion and to any request to amend based on discovery is, by its nature, a threshold inquiry, and logic strongly suggests that it occur prior to discovery. The Wayfarer defendant's motion thus seeks a duplicative exercise that can only have the effect of causing delay. It's not duplication, though. It's a different motion. Meanwhile, the Wayfarer defendants will suffer no prejudice from having their present motion evaluated on the basis of the summary judgment evidence rather than the second amended complaint's allegations. They have not sought to stay discovery or otherwise suggested that anything about the case schedule should change based on the filing of their motion. By contrast, Miss Lively will suffer significant prejudice from having to file what is effectively an motion to summary judgment. It is not. Getting annoyed now. While discovery is still ongoing. Indeed, the only practical difference between the process for resolving this motion and a summary judgment motion filed at the appropriate time is that to respond to this motion, Miss Lively will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline, including depositions of Mr. Baldoni, Mr. Heath and Wayfarer, Mr. Sarowitz, Ms. Nathan and Mr. Wallace, not to mention the expert discovery process that will be ongoing for several weeks after. She is talking crap. The court should accordingly deny the motion without prejudice to renewal of the arguments raised therein at a later stage, or exercise its discretion to hold the motion in abeyance until trial. In the alternative, Miss Lively respectfully requests that her deadline to respond to the motion be extended to and including October 27, 2025, 3 days after the deadline to exchange expert rebuttal reports. Unless extended, the current response deadline is October 10th, 2025. This is Miss Lively's first request for an extension of this deadline. Pursuant to Rule 1D of the Court's individual rules and practices, Miss Lively states that the Wayfarer defendants oppose the extension, but did not provide any reason. For the reasons given above, even if the court is inclined to permit full briefing of this motion in the final days of discovery, such an extension would be warranted. And again, I refer everyone back to Lively's response when Wayfarer asked for an almost identical extension of time. So anyway, thank you for joining, and I will see you for the next filing.